This is great. This is great, Craig. I'm getting a lot out of this. Just a couple of questions around trusts.
Yeah.
So the idea of a testamentary trust. Can you give me a bit of info around that? What are they? How do they work? How is it relevant for me?
Yeah. So this conversation is going to probably give you a headache by the end of it, but
I've already got a headache.
You do? Okay, good. Yeah. Welcome to my life.
I'm thinking, how do you do this?
So so whenever someone asks me about a testamentary discretionary trust or testamentary trust in a will, I kind of cringe a little bit on the inside. They're very unless that person's a financial planner or someone that really knows what's going on with trust and asset investments and management stuff. Mm-hmm. Basically, so in a normal will, a standard will, you'd have a trust created in that. They call it a bear trust. And
B-A-R-E or B-E-A-R?
Not like the grizzly, like the other one.
Okay.
You know.
Like naked?
Yeah.
Okay.
That's right.
Okay.
A naked trust. So that's where I say, look, as at the date of my death, I appoint an executor, and that person's going to hold on to that asset and be the legal owner of that asset, and it's for the benefit of you as my beneficiary.
Right.
The best way of describing this, or analogous to this, is when you have a car and you register the car, and you've got the registered owner of the car, and they're the responsible owner of the car, they're the legal owner of the car, and then the other person that might actually own it might be your mum or your next door neighbour or something like that. They actually paid for it and owns it, and it's for their benefit. So that's what they call an example of the separation between legal ownership and beneficial ownership. And so this is where people struggle a bit, because trust is pretty complicated, but that simple trust in a will is, I give my executor my estate when I die. They're going to hold on to my cash, my house, my car, whatever it is, upon trust for my beneficiary.
Sure.
There's no discretion there. It's a bare trust. It must go to that beneficiary. I mean, they can disclaim it and say they don't want it, but the number of times that's happened is not that frequent.
Yeah.
So testamentary trust or a testamentary discretionary trust is a will that has. Usually it's quite simple at the front, but it's got lots of, like a big document at the back of it. And it's basically a trust schedule or trust deed. And the point of it is that it's like saying, instead of saying in a normal will you give it just directly to one person, your executor holds it on trust for that person, that beneficiary. I give everything I own at the date of my death to my executor, who will become a trustee for the money or the assets, and they will exercise their discretion to pay money every year or give capital every year to particular beneficiaries, or only one beneficiary or a group of beneficiaries. And that's where it's called the discretionary trust, because the trustee then has a discretion that they could choose not to give any money in 1 year, and then might give all of it in another year, or
right. Okay, gotcha.
So that it's essentially an inter vivos family trust. You hear these people go, "Oh, you got a family trust," like for businesses and stuff. So it's like that, but attached to a will, and it comes into effect once that person dies. And so to kind of flow on from that, like why would you have them, when would you have them, all those kinds of questions. I will almost always try and talk my clients out of having a testamentary discretionary trust in a will, unless they fall into a number of kind of exceptions that I consider it's appropriate. One is where each beneficiary, usually a child or a spouse, is going to receive more than about $500,000 worth of assets.
Gotcha.
Because the cost every year, you've got to do tax returns for the trust, and there's an administration fee. It's not much, but it's a waste of money otherwise. It outweighs the benefits of the structure. So, and I'll talk about why it's a good idea to have these trust structures in a minute. But who's appropriate for? that would be one scenario. So you've got to have, and it's usually the more high net worth clients.
Right.
That's why usually with the financial planners that send the clients that've got bigger asset base, so they're usually the most suitable for that. Another example of when I would consider using a discretionary trust in a will is where you might have one or two kids who are spendthrifts. They might be reasonably young, they might be immature. You might want someone in there, a couple together, usually with a high asset amount. You always hear the story, oh, my son's going to go off and buy a Lamborghini. I mean, it's ironic because that's exactly what I would do as a
of course,
young lawyer.
Yeah.
Call myself that.
Yeah.
So, but
Are you a millennial? Do you fit
no,
that
I'm a
category?
Gen X. I'm a Gen X
Okay.
officially, but yeah, I'll be. I'll call myself a millennial. I look like a millennial.
You've got great skin.
Yeah,
I've commented on your skin before.
yeah.
Do you do you have a perspective on with regards to this kind of thing? These age periods, Gen X's, Gen Y's, millennials.
Everyone blows it at the end of the day. It's gone before, in my cynical experience, it's gone before it's even, in their pocket.
Yeah.
Anyone, that is, doesn't matter what age.
Yeah.
But having said that, we do normally have a vesting age of about 25 is a recommendation in the trust deed before they can do certain things, and I'll come to that in a minute. But so you've got higher value estates. You've got people who might be spendthrifts or drug addict kids or whatever, and you want someone else managing that discretion and giving them the money. And another benefit of it is the trust can own assets. So the trust might buy a house and the trust owns the house, not the kid. The kid can use the house, but the trust owns it. So you're always protecting the corpus or the capital of the trust from being wasted, and they still get the benefit of it. Another one is if you've got someone with a disability, a person with a disability, there are special purpose disability trusts that you can do, and there's different tax concessions and things like that for that, but there's special rules about that. But you might have someone with a very, very mild disability and you want to use a discretionary trust. So those are kind of the broad brush situations. Then the question is why. Well, it's all good. This is what it is, and this is what it does. This is when I would use it, but why would I use it? It has, first of all, a number of tax concessions still, which haven't yet been eroded. In a normal family trust, your kids can only, these days, claim the $400 tax-free threshold, I think it is. It's pretty small. But in a testamentary trust, it's still considered to be a vehicle for inheritance, and so they can claim the full, whatever it is, $18,750 or $19,000 of tax-free threshold per kid. So if you've got 4 kids and they're all, and a spouse, and they're all getting a distribution from the trust each year, your trust might be making income itself in its own right, but then it's claiming you might be getting $60,000 to $80,000 worth of tax-free tax-free distributions every year. So tax minimisation is one reason for it. Another reason for it, obviously mentioned, is that you're protecting the assets for the use of those beneficiaries. One is creditor protection.
Sure.
So, for example, if one of your kids is running a business or they're liable to be sued, or there's an issue against creditors, if you die, then under a normal will it says I give a quarter of my estate to my son or half of my estate to my son. The trustee in bankruptcy can actually come and take that, because they're saying, well, your dad's died or your mum's died, you're getting a quarter of the estate, we'll use that to satisfy the bankruptcy. Whereas if it is in a testamentary discretionary trust, the trustee will actually say, well, I'm just choosing not to make any distributions while the bankruptcy is in place. And like I said, that separation of legal and beneficial ownership, they can say, sorry, he doesn't own it beneficially, he's only got a right of consideration in the trust, and then they wait for the bankruptcy to go, and then there's that. The other...
so it's greater control, really, isn't it?
Yeah.
Choice and
I mean,
Which is
the
ideally what you want.
the big one is the family court that people are worried about.
Okay.
So if you've got kids who they might be in a bit of a relationship with someone that you're not particularly fond of as a parent, and you think this is going to be a bit of a drama, and you've got
Yeah.
significant wealth in that family group, if that person is going through a matrimonial property dispute in the family court, if, say for example, the mum or dad's died, you know, in proceeding or during those proceedings, then ordinarily, if it's a normal will and it says I give my inheritance to my son, then they're going to say, well, that's, if it's not a matrimonial resource, it's at least a financial resource that husband or wife can rely on.
Yeah.
Whereas in the family trust environment, it is, in the testamentary trust environment, they're saying, well, again, it's discretionary, the same as the bankruptcy protections. So those are the main things. I guess the problem is we get some clients coming in saying, oh, you know, my kid's going through a bust up or whatever, can I do this in my will? Well, the family court's very powerful, and if they smell, you know, there's some kind of shonky, you know, illusory transaction going on, they will possibly reach behind the, you know, the curtain and claw those assets in. So, and probably the biggest point, which ties in with this, is that you can't create a testamentary trust retrospectively.
Right.
So you can't die, you've got a normal will, and your kids go, oh, actually, I like it in a testamentary trust environment.
Yeah.
It has to be set up beforehand.
Okay.
And again, from the family court perspective, if it's set up many years before any bust up family dispute, they're going to say, well, you haven't deliberately created that structure to avoid the family court. You did that many years ago as a legitimate means of transferring your assets. So I guess that conversation really is all about the kind of testamentary trusts, when to use them,
Yeah.
why we'd use them, but
Yeah.
it's in pretty limited circumstances. But they're very, very handy tools to have for those reasons.
Interesting. Changing gears a little.